Steco.
Welcome to the instructional video on establishing a foreign invested company in Vietnam. You are probably planning to invest in Vietnam but do not know where to start. Are not aware of the risks, conditions, and legal aspects. So let's go into the details with Steco right now. Overview. 1. Definition of foreign invested company. A foreign invested company is an economic organization established under Vietnamese law, in which a foreign investor contributes capital, purchases shares, or sets up a new company. According to Clause 22, Article 3 of the Law on Investment 2020, the definition of foreign investor is determined as a foreign national or an organization established under foreign law conducting investment and business activities in Vietnam. Therefore, if a company in Vietnam has any percentage of capital contributed by a foreign investor, it will be considered as having foreign elements and may be required to carry out investment procedures under the Law on Investment 2020. 2. Forms of capital contribution and foreign investment in Vietnam. According to Article 21 of the Law on Investment 2020, foreign investors may participate in the Vietnamese market through the following forms: establishing a new economic organization in Vietnam, contributing capital, purchasing shares, or acquiring equity in an existing economic organization, implementing independent or joint investment projects, investing under BCC contracts, business cooperation contracts, investing in the form of PPP, public-private partnerships, in permitted sectors. Each form of investment leads to different legal procedures, thereby affecting the determination of licensing obligations, investment conditions, and the management regime. 3. Reasons to thoroughly understand the law when establishing an FDI company. The establishment of a foreign invested enterprise is not as simple as establishing a domestic enterprise, because it requires 2 steps: applying for the investment registration certificate and applying for the enterprise registration certificate. Certain sectors only allow foreign investors to participate with a limited capital ratio or require specific conditions. For example, insurance, education, logistics, real estate. There are sectors prohibited or restricted for foreign investment. According to Appendices 1, 2 and 3 of the Law on Investment 2020, obligations for managing foreign investment capital include opening an investment capital account, contributing capital within the deadline, submitting periodic investment activity reports, etc. Therefore, referring to the law, international treaties, and sector-specific regulations is a mandatory condition to reduce legal risks and optimize investment effectiveness. Conditions for establishing a foreign invested company in Vietnam. The establishment of a foreign invested company is not merely an administrative procedure, but a process of checking the compliance with investment conditions under Vietnamese law and international treaties. Below are important groups of conditions that investors need to pay attention to. 1. Investor eligibility. According to Clause 22, Article 3 of the Law on Investment 2020, a foreign investor is an individual or organization established under foreign law. In order to be allowed to establish a company in Vietnam, the investor must have full civil legal capacity and civil act capacity, not fall into the cases prohibited from investment under Clause 2, Article 6 of the Law on Investment 2020, for example, drug trafficking, prostitution, undermining national defense and security. Note: some countries or territories may be restricted from accessing the Vietnamese market, depending on international commitments, WTO, CPTPP, EVFTA. 2. Business sectors for investment. Before investing, the investor must determine whether the intended business sector belongs to the list of prohibited investment sectors. According to Appendix 1 of the Law on Investment 2020, conditional investment sectors for foreign investors. According to Appendix 4 of Decree 31/2021, Decree of the Government, conditions may include limitation on capital ownership ratio, for example, not more than 49% in the aviation sector. Requirement for Vietnamese partners, for example, transportation services. advertising, requirements on expertise, experience, legal capital, etc. Example: a foreign investor wishing to open a kindergarten must ensure a minimum investment capital of $1 million United States dollars, according to Decree 86/2018, Decree of the Government. 3. Forms of investment. According to Article 21 of the Law on Investment 2020, foreign investors can invest in Vietnam through the following forms: establishing a new economic organization, limited liability company, joint stock company, contributing capital, purchasing shares or capital contributions in an already established Vietnamese company, investing under contracts, BCC, PP. The choice of investment form will directly affect procedures to be carried out. Is investment registration certificate required? Time for dossier processing. Control rights of the investor in the enterprise. If the foreign investor holds 51% or more of the charter capital, the company is considered an economic organization with foreign investment capital and will be subject to regulations applicable to foreign investors, according to Clause 2, Article 23 of the Law on Investment 2020. 4. Location of the investment project. According to Article 32 of the Law on Investment 2020, the investor must clearly register the location of the project implementation. Depending on the project location, the agency granting the investment registration certificate may be Provincial Department of Planning and Investment, Management Board of Industrial Zones, High-Tech Zones, Economic Zones. Location requirements must be suitable with the development planning of sectors, industries, and local infrastructure, not violate national defense and security conditions. Example: an FDI enterprise wishing to set up a factory in an industrial zone must have a legitimate land lease contract or factory lease contract before being granted the investment registration certificate. 5. Ownership ratio and capital contribution limit of foreign investors. The capital ownership ratio of foreign investors will depend on the business sector, whether limited or not, Vietnam's commitments under WTO and FTAs, provisions of specialized laws, securities, banking, telecommunications. Example: advertising sector. Foreign investors are only allowed to contribute a maximum of 49% capital, WTO commitment. Retail distribution sector must establish a joint venture, and business license conditions are reviewed after company establishment. If not in a restricted sector, foreign investors may own up to 100% of the charter capital. Determining all the above legal conditions is a crucial step before submitting the investment application. In order to avoid license rejection, multiple dossier adjustments, or worse, being penalized or having the investment registration certificate revoked after commencement of operations. Legal procedures for establishing a foreign invested company in Vietnam. The establishment of a foreign invested enterprise in Vietnam must go through two main steps. Step 1. Apply for an investment registration certificate, IRC. Step 2. Register for enterprise establishment, ERC. Depending on the business sector, capital contribution ratio and investor's nationality, sub-licenses and other administrative procedures may arise. Below is the detailed process. 1. Preparing the application dossier for the investment registration certificate, IRC. Legal basis: Article 36 to Article 40 of the Law on Investment 2020, Article 33 to 38 of Decree 31/2021, Decree of the Government. The dossier includes a written request for implementation of the investment project, using Form AI-1. Circular 03/2021, Circular of the Ministry of Planning and Investment. Investment project proposal, explanation, objectives, scale, location, capital, progress, copy of documents proving the investor's legal status. For individuals, passport, ID card. For organizations, business registration certificate. Financial statements. Proposal for land use demand or lease contract for premises. Documents proving financial capacity, savings book. Bank balance confirmation. Financial statements. Explanation of experience and capacity if investing in a conditional business line. Note: if the project is outside industrial zones, it is necessary to obtain an investment policy approval if falling under the provisions of Article 30.31 of the Law on Investment 2020. 2. Procedures for applying for the Investment Registration Certificate, IRC. Receiving authority, Provincial Department of Planning and Investment, for most projects. Management Board of Industrial Zones, High-Tech Zones, if investing in these zones. Processing time, 15 working days from the date of receipt of a complete and valid dossier, based on Article 38 of the Law on Investment 2020. Result: the investor receives the Investment Registration Certificate, IRC. Note: if the dossier involves special elements, special nationality, sensitive industries, need for consultation with ministries, the processing time may be extended to 30 to 45 days. 3. Enterprise establishment. Registering for the Enterprise Registration Certificate, ERC. Legal basis. Article 22 to 27 of the Law on Enterprises 2020, Decree 01/2021, Decree of the Government. The dossier includes application for enterprise registration, company charter, list of members for limited liability companies or founding shareholders for joint stock companies. Copy of ID card, passport or business registration certificate of the investor. Decision on capital contribution, appointment of legal representative, granted IRC, receiving authority, Business Registration Office, Department of Planning and Investment. Processing time, 3 working days from the date of receipt of a complete and valid dossier. Result: issuance of the Enterprise Registration Certificate, ERC, and tax code. After obtaining the ERC, the company must make its seal, announce enterprise information, register for tax, open a bank account, and proceed with other post-licensing procedures. 4. Applying for sub-licenses, if operating in conditional sectors. Some business sectors require specialized licenses. For example, education operation license, based on Education Law 2019. Logistics, business license for logistics services, based on Decree 163/2017, Decree of the Government. Real estate, license for eligibility to conduct real estate business, based on Law on Real Estate Business 2014. International travel license, based on Tourism Law 2017. Granting sub-licenses may require additional conditions on legal capital, experience, facilities, personnel. 5. Opening investment capital account and contributing capital on time. Legal basis. Circular 06/2019, Circular of the State Bank and Law on Investment 2020. Foreign invested companies must open an investment capital account in foreign currency or VND at an authorized commercial bank. All capital contributions from foreign investors must be transferred through this account. Capital contribution deadline. Within 90 days from the date of issuance of the ERC, according to Article 47 of the Law on Enterprises 2020. If the deadline is exceeded without full capital contribution, administrative penalties will be imposed and capital ratio must be adjusted. Full documentation must be prepared for each fund transfer, clearly stating the purpose as capital contribution for investment, for the bank to disburse according to regulations. Properly and sufficiently implementing the above legal procedures not only ensures lawful establishment of a foreign invested company, but also forms the basis for sustainable operation, avoiding penalties, license revocation or denial of specialized licenses in the future. Common mistakes to watch out for. In our experience of consulting and handling dossiers for many investors, we realize that many difficulties do not stem from complex legal procedures, but from lack of thorough preparation, conceptual misunderstandings, or incorrect assessment of legal conditions. Below are common mistakes that foreign investors and Vietnamese enterprises should pay special attention to. 1. Confusion between 100% foreign-owned company and company with foreign capital. Many investors believe that only when they hold 100% of the capital do they need to carry out foreign investment procedures. This is a serious misconception. Legal basis. According to Clause 2, Article 23 of the Law on Investment 2020, an economic organization is considered to have foreign investment capital and must carry out investment procedures as a foreign investor if the foreign investor holds 51% or more of the charter capital. An organization with foreign capital holds a majority of charter capital in the proposed enterprise to be established or invested in. Common mistake. Holding 49% but not checking the business line may violate market access conditions and be denied licensing. 2. Failure to check investment conditions for foreign investors. Many businesses only look up industry codes in the VSIC, Vietnam Standard Industrial Classification, system without comparing them with the list of conditional business lines for foreign investors. Legal basis. Decree 31/2021, Decree of the Government. List of conditional business lines for foreign investors. WTO, CPTPP commitment schedules. Market access limitations. Example, the logistics sector has conditions on joint ventures and capital ratio. And a 100% foreign investor is not eligible but still submits the application, resulting in rejection. 3. Violation of capital contribution deadline after establishment. After being granted the Enterprise Registration Certificate, ERC, foreign invested companies must fully contribute capital within 90 days. Legal basis. Clause 2, Article 47 of the Law on Enterprises 2020. Members must contribute full capital within 90 days from the date of issuance of ERC. Circular 06/2019, Circular of the State Bank. Capital must be transferred through the investment capital account opened at a Vietnamese bank. Consequences if violated. Subject to administrative penalties, under Decree 122/2021, Decree of the Government. Must adjust and reduce charter capital. Difficulties in procedures for sub-licenses, bidding, etc. 4. Failure to register the investment capital account correctly. A common error is contributing capital from a personal or regular account without opening a direct investment capital account, DICA, at an authorized commercial bank. Legal basis. Circular 06/2019, Circular of the State Bank. Articles 5-6 clearly stipulates that each investment project must have a separate capital account. Transfers from the wrong account will not be certified by the bank, affecting the right to contribute capital, transfer profits, or repatriate capital. In practice, some investment projects are entirely delayed just because of unauthorized transfers from foreign personal accounts. 5. Arbitrarily signing contracts, renting premises, or paying taxes before obtaining an investment license. Some investors sign lease agreements for factories, purchase machinery, or even sign labor contracts before the company is legally established and licensed. Practical consequences. Cannot include assets as capital contribution. Cannot declare eligible tax-deductible expenses. Risk of being declared civilly invalid transactions due to unauthorized legal entity status. 6. Failure to submit periodic investment activity reports. Once the company is operational, investors are obligated to report investment activities quarterly and annually. Legal basis. Article 72 of the Law on Investment 2020. Article 40 of Decree 31/2021, Decree of the Government. Reports must be submitted to the Department of Planning and Investment or the Industrial Zone Management Board. Common mistake. FDI enterprises failing to submit reports result in warnings, inspections, and being denied approval for project expansion. After going through all the analysis steps, it can be seen that establishing a foreign invested company in Vietnam is not simply about filling out forms and submitting documents, but a multi-layered legal process that requires investors to have in-depth knowledge, thorough preparation, and proper legal support to address these challenges for businesses. Steco, as your trusted legal companion. not only assists in obtaining licenses but also analyzes business lines and market access conditions, verifies international commitments and relevant sectoral regulations, prepares investment dossiers logically, legally, and in accordance with standard templates, anticipates legal risks, such as capital ratio or conditions for auxiliary business lines, provides advice on taxation, profit remittance, and dispute prevention in the future. We accompany you like an in-house legal department, supporting you from the planning stage to operation and expansion. Contact us now to receive free consultation from Steco's team of lawyers.